All right, good morning to everyone. We are here this morning in the state of Florida versus Charles Adelson, 2016 CF 3036. And let's see, we have Ms. Kappelman and Ms. Dugan on behalf of the state, and Mr. Roshbaum and Ms. Myers on behalf of Mr. Adelson, who is here in the courtroom. All right, good morning to everyone. Okay, we're here this morning on the defendant's motion for pretrial release and request for Arthur hearing. We have some people I know that are listening in by Zoom. Ms. Kappelman, we have that all taken care of?
I think so, Judge.
Okay, great. And so they won't be participating, but they're just listening in. And anything that we need to address before we get to the testimony? I'll go to the state first. Ms. Kappelman?
No, sir.
Anything for the defense?
No, Your Honor.
Okay. I think we're all familiar with the standard here. I've reviewed the motion. I'm familiar with the case, and so I think we'll move right to testimony. And so it's the state's burden. Ms. Kappelman, how many witnesses will you be calling today?
No witnesses, Judge, just argument and exhibits.
Okay. Do you want to offer your exhibits into evidence first before your argument?
I was going to I have a PowerPoint presentation. I was going to kind of admit them as I go along.
All right. We can do that. If you have any objection, then.
Sorry to interrupt you. You should have an exhibit list before you.
Okay, I do have that. And then, so I know if you have a PowerPoint, if there's any objection at any time, then we'll stop the PowerPoint and then take care of that at that time.
Thank you, Your Honor. Is Your Honor able to observe the PowerPoint on your screen?
Well, I was, but it just went off. Now I can see it, yeah.
Okay. All right. So as Your Honor mentioned, we are all familiar with the Arthur hearing standard of proof of guilt is evident or the presumption is great. Obviously, we start with this man, Professor Dan Markel. We've had 2 trials related to the murder of Professor Markel. His family has also prepared a statement for your consideration, which I would like to read at the conclusion of this presentation. The investigation into his life and death revealed that his ex-wife and former in-laws had a strong motive to kill him in order to resolve a messy custody and relocation dispute over his 2 sons. On July 18, 2014, now over 8 years ago, Professor Dan Markel was gunned down in the driveway of his home. He suffered 2 gunshot wounds to the head, which did not bring about his immediate death. Instead, he suffered for some 13 hours in the hospital before succumbing to his injuries. 3 people involved in the plot to murder Professor Markel have already been convicted. Luis Tato Rivera on October 4, 2016 by a plea of no contest. Sigfredo Tudo Garcia on October 15, 2019 by conviction by a jury of his peers. And Catherine Katie Magbanawa on May 27, 2022 by a second jury. I have prepared a binder containing 16 discs of the testimony from Ms. Magbanawa's trial in May of this year, which Your Honor presided over. I know you're very familiar with it, but there is no transcript in existence yet of that. So I would like to offer the discs, which are certified by the official court reporter as true and accurate copies of the testimony that was taken in this case as State's Exhibit A.
Any objection?
No objection, Your Honor.
Be admitted as State's Exhibit A.
And Judge, the evidence in this case showed that the link between the men that came to Tallahassee to murder Dan Markel and the family members with the motive to kill him was Catherine Magbanawa, and specifically her romantic relationship with this defendant, Charles Adelson. These photos were introduced in the most recent trial to evidence that the 3 convicted killers knew each other and that one of them was intimately connected to this defendant. Dan Markel's ex-wife, Wendy Adelson, testified that her brother, the defendant in this case, repeatedly made jokes that he had looked into hiring a hitman to resolve the issues between her and her ex-husband, Dan Markel. but that buying her a TV was cheaper. She further testified that the defendant did buy her a TV as a divorce present, the same TV that she was having repaired in her home around the time that her ex-husband was being murdered. The mention of a TV would later come up again in the trial through recorded conversations between the defendant and his mother, Donna Adelson, where Donna refers to the undercover law enforcement extortion operation as a TV, indicating this TV is going to be about $5,000. Witness Jeffrey Lacoste, Wendy Adelson's boyfriend around the time of the homicide, testified that he also heard the joke from Wendy Adelson that her brother had looked into hiring a hitman, but that the TV was cheaper. He also testified that in a very serious subsequent conversation, Wendy revealed to him and confided in him that her brother really had looked into hiring a hitman to kill Dan Markel, and that was shortly before the hit was executed. Luis Rivera indicates that he was hired by Sigfredo Garcia, who was hired by Catherine Magbanoa to kill Dan Markel. His understanding was that this job originated from the dentist that Catherine Magbanoa was dating, that's this defendant, because his sister, Wendy Adelson, needed to get her kids back. An abundant amount of communications records are critical to this case. I want to just touch on a few highlights from the most recent trial of Catherine Magbanoa, which are introduced into evidence as States A. This slide shows Catherine Magbanoa's location on June 2nd, 2014, consistent with her being present at the time and location that the first rental car was rented by Sigfredo Garcia for the purpose of doing the killing. During this time frame, Catherine Magbanoa made a 2-minute phone call to Charlie Adelson at 8:57 p.m. Then along her route home, she placed a second call to Charlie Adelson, which lasted 25 minutes, so about the whole time she was en route back home. And this slide here shows that the data points associated with that call. This slide shows the phone activity prior to the rental of the Prius, which was the vehicle that was ultimately used by the killers to drive to Tallahassee. Calls are observed going back and forth between Catherine Magbanoa and Sigfredo Garcia, and then between Catherine Magbanoa and Charlie Adelson, consistent with Magbanoa as the conduit for the flow of information between the two men. The first call after the murder from either Rivera or Garcia was Sigfredo Garcia placing a call to Catherine Magbanoa. Per Luis Rivera, Garcia advised Magbanoa the job was done, and Magbanoa replied, "I know." After the murder, there's a flurry of communications between the parties. In this slide, the murder is represented as the red line. And the text messages between Magbanoa and Adelson on the day of the murder, where they appear to be making plans to hang out at Charlie Adelson's house that night. The state's theory is that the purpose of this visit was for Magbanoa to pick up the stapled money from Adelson, which was payment for the murder, and cuts of which would be delivered not only to Magbanoa, but also to Garcia and Rivera the next morning. This slide shows Catherine Magbanoa's last 2 calls on the day of the murder, July 18th, 2014. Both were to Charlie Adelson at 10:12 p.m. and 10:20 p.m. After these calls, her phone is consistent with being turned off until the next morning, which was the morning of the money drop. This slide shows Magbanoa's locations on the morning of the money drop, consistent with her phone coming back online in a direction of travel south, consistent with having come from Charlie Adelson's residence and traveling toward the location of the money drop. The next slide shows locations of the handsets of the parties, consistent with the money drop occurring at Luis Rivera and Jessica Rodriguez's residence between 10:30 a.m. and 11 a.m. on July 19th, 2014. This slide shows Magbanoa's handset consistent with her leaving the money drop location and heading toward the home of Yendra Velasquez Mascaro to pick up her children. Mascaro testified that this was the only time she ever kept Magbanoa's children overnight, and that when Magbanoa picked the children up, she indicated that Charlie Adelson's brother-in-law had been involved in a car accident. June Umchinda is a witness who was one of Charlie Adelson's girlfriends subsequent to Magbanoa. Umchinda testified that it is Charlie Adelson's practice to keep his money in stapled stacks of $100 bills. And per Luis Rivera, on the day after the murder, he received stacks of $100 bills stapled into $1,000 stacks as payment for his role in the murder. That money was delivered to him by Garcia and Magbanawa the morning after the murder, and the morning after Magbanawa made plans to spend the night at the home of Charlie Adelson. The financial evidence in this case is important as well for your consideration. The evidence showed that Charlie Adelson deals in a largely cash business, that his family has a safe containing large amounts of cash, and that there is a safe in his residence containing cash as well. An analysis of Catherine Magbanawa's bank records around the time of the homicide show a striking spike in cash contemporaneous with the murder and an increase in cash deposits over the next year. Magbanawa also received breast augmentation surgery shortly after the murder, an expense that was paid for in cash, half of which was provided by the defendant per June Umchinda. The defendant, Magbanawa, received a Lexus vehicle which was previously the property of this defendant's father, Harvey Adelson, for free or at a very discounted price, as the title indicated a nominal fee was paid for the vehicle, but no financial documentation could be located to evidence the actual payment. And most importantly, financially for these purposes, the defendant put Catherine Magbanawa on the payroll of his family business, beginning very shortly after the murder and continuing up until the first arrests were made in this case. Magbanawa collected over $17,000 from the Adelson Institute with little to no evidence that she did anything to earn the payments. In Magbanawa's most recent testimony, she could not articulate anything she did for the business other than make one appointment, or for Charlie Adelson, and said the defendant was just doing her a favor, even though they were no longer in a dating relationship. The undercover operation in this case was designed to illuminate the co-conspirators and their respective roles in the conspiracy. When the defendant's mother, Donna Adelson, was approached on the street by an undercover operative posing as a gang member who knew about her role in Dan Markel's murder and was attempting to extort $5,000 from her, she called this defendant, Charlie Adelson, and said she needed to speak to him in person as she was approached on the street by someone, and it had to do with, quote, the two of us. Donna Adelson tells Charlie Adelson that the extortionist mentioned his ex-girlfriend. And Judge, at this time I would ask to introduce State's Exhibit B for the purposes of this hearing. B is a disc containing the wire calls that were introduced into evidence in the most recent trial. The wire calls are certified by the clerk of court as a true and accurate copy of the exhibit that was introduced into evidence.
Any objection?
No objection, Your Honor.
Be admitted as State's Exhibit B.
And although there were many ex-girlfriends to choose from, this defendant called only one ex-girlfriend, Catherine Magbanawa, whereby a very revealing string of conversations is had over several days captured in State's Exhibit B for purposes of this hearing, demonstrating the flow of communications to always occur between the co-conspirators in this particular pattern. After the undercover operation, or the bump as it is commonly referred to, Charlie Adelson and Donna Adelson meet to discuss the issue in private, followed by Charlie Adelson's recorded meeting with Catherine Magbanawa in the Dolce Vita restaurant, whereby he can be heard making several incriminating statements to her about the interaction between the undercover officer and his mother. And at this time, Judge, I would ask to move into evidence the recording from the Dolce Vita restaurant, which was introduced into evidence in the previous trial, also certified by the clerk as a true and accurate copy of that exhibit as State's Exhibit C.
Any objection?
No objection, Your Honor.
Be admitted as State's Exhibit C.
And some of the statements that the defendant made that I'd like to highlight for Your Honor that were captured in this exhibit are, quote, if they had any evidence, we would have already gone to the airport. The problem is, even if they bug this, even if they bug your home phone, nobody is going to, and that's unintelligible. You've got to understand, in order to prove it, You have to put that person at the scene at the time, not in the car. Because the fact is, it's like, even if, let's say you just sat in the car, right? And then I go ahead and I commit a crime. And then I go, but your DNA is in the car. And I go, yeah, Katie was in my car. And she got out and she did this horrible crime. Okay, so they come and get the DNA in the car and go, oh, Katie was in the car. No, Katie sat in the car for 2 minutes and they got in the AC and then they got out of the car. Katie has nothing to do with me robbing the Burger King. So even if I can prove that, yeah, Katie was with me, can you put Katie at the Burger King? I can say that she sat in the car, yeah. So discussing the quality and implications of the potential evidence in the case. Later, he says, let me ask you a question. When everybody was there the next day, did any of you take any money? It's not like you're driving around in a Bentley, cruising around in a mega yacht, referencing the money drop, wanting to know if there's anything flashy going on with the money that could draw attention to them. Later, he says, so if you didn't witness it, you only heard a rumor on the street that this person did something. Do you know what that's worth? 0. Then what you do is you wear a wire. You get this person talking, and if you can get the person to confess on wires, then you have something that you're charging. You have a confession. You have an admission of guilt. So discussing the bump as a possible law enforcement undercover operation, whereby somebody wearing a wire is trying to get information that could be used against them in the case. What if you rented a car today? I go, Katie, can I borrow it for the weekend? And I'll bring it back on Tuesday. You go, yeah, sure. So you rented a car, you've been in that car, I drive it to effing Orlando, I rob a McDonald's in Orlando, I come back and I go, here's the keys, Katie, and you go, okay, thanks. Yeah, you rented it, but, or what if you were effing out all weekend and you didn't even know I took your car and I did something and I brought it back, okay? My point is, I don't have any knowledge of what went on. Evidently, this person either is pretending to or does. I don't want someone paying visits to my parents. A few lines down, and I think if they thought I had something to do with it, they would find me and talk to me. You know what I'm saying? Like, talk to the person who's involved, not fucking people who aren't involved. And I'm not involved, but if they knew our relationship, your relationship is with me, not my family. Later, the discussion of if this is a person that does have information about the murder that has approached his mother. Defendant says, okay, next thing you know, this person is singing. Other people start singing. As soon as they have him, he starts calling your name out. Oh, my parents are going to have to say, and there's some discussion about the guy, that his parents will have to report that the guy approached. Then I want to give them the money, but what I don't want to get involved in is next Tuesday, he's asking for $10,000. So this was my idea. I give you the money, you contact, there's some unintelligible there. Listen to what I'm saying. This is why I'm saying it. I give you the money, you talk to him on the phone. So Charles Adelson is instructing Catherine McBanoa what to do to resolve this issue of the undercover operation. This is what I want you to do. I want you to call up this person and say that I got a call from some friends of mine who says that you reached out to them and that you mentioned my name. And remember, protect your name, something about protect your name recently. So what you're going to say is, I got a call from some friends of mine who said that you had reached out and that you had mentioned my name. These people want to go to the police because they had nothing to do with what you're talking about, okay? And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated, so I'm going to give you something as charity to help the less fortunate. But do not contact these people again or they're going to the police. Again, instructing Catherine McBanoa on exactly what to say when she calls the undercover operative / gangster that's approached his mother. That way he gets his money. He also knows that you know everything. that you may have a friend who may not be so cool with what's going on too, who may know people, who knows how to handle people like this, and that this is a effing one-time thing. This is charity to help somebody out. If it's this guy, maybe in the back of he knows something times a million. And now he's effing with his wife, and he's effing with him, and you F with something, you F with the king himself. You better kill him because he's going to be a big problem, and he knows who you are. If he can't do it, he'll have someone else do it. And so help me God, if they fuck with my family, it's going to be like effing that Nazi shit. Because this will be done. You know what I'm saying? I mean, Katie, I don't care what I spend, okay? I swear to God. Later he says, like, you know it. I don't have to sit here and tell you what I would do. I could show you what I could do. You know what I'm saying? Like, you know how I am. Like, I look for things to do. You don't ask me for shit. I'm the one that's like, hey, somebody's birthday's coming up. I got you. And I'm the one who's like, hey, I'll sell you a Lexus for a very good price. You know what I'm saying? Like, I don't have to tell you, I show you. There's a difference. Referring to the favors and financial benefits that he gives Catherine Magdanowa. Later, Charles Adelson says to Catherine Magdanowa in this conversation, listen, you giving some money is not an admission of any kind of guilt. Later, there is a third meeting between some of the parties. This one is Charlie Adelson and Harvey Adelson. They meet at a Matsuri, which is a sushi restaurant, on April 21st, 2016. This is an item which has not been previously introduced into evidence. It has been provided in discovery. And at this time, I'd ask to introduce a copy of this statement, which I've marked as Exhibit D on a disc.
Any objection?
No objection, Your Honor.
Be admitted as Exhibit D.
And this is relatively short, but I'd like to publish it for Your Honor.
All right. So you're going to play the audio?
Yes, sir.
Okay.
Hopefully you'll be able to hear it. There are captions as well.
There is one. Yeah, you can say it all day long. I can even tell you it's a giant stadium. That's it. Now, all day long. It's not done like that. And oh, I know that we just talked about it. They got I was surprised they didn't move today. One or the other. One or the other, but the woman's usually the weaker choice. You know, someone is going to give in, so it is what it is. That's one for the yes, that's very right. I think it's. I actually think it's you know, at some point, somebody they had to reach out. They have to do something. They have to sort of listen. And they ask you a question, yes or no. Someone's just going to say no. So there has to be some kind of tactic to come in to the introduction, you know, where it's like, it makes sense, it really does. I didn't think they were that smart. And the funny thing is I'll take it. Yeah, thank you. How do you understand this? If 50% of people want to cooperate, why would you not? Like, because it's the attitude of, all right, I'll pay to make it go away, but it's utter nonsense. Yeah.
Judge, at this time, I'd ask to introduce a statement that was prepared by the Markel family as State's Exhibit E.
All right, any objection?
No objection, Your Honor.
Be admitted as State's Exhibit E.
And Judge, before I move on from that, one additional statement that I failed to bring to your attention from the Dolce Vita recording, State's Exhibit C, is where Mr. Adelson indicates, you know, there's a discussion of every Tom, Dick, and Harry is going to show up and want assistance if they pay out the money to this thug that's approached his mother. And there's a comment in which Mr. Adelson says, hey, you know who this is coming from? The inside. Right. And State's Exhibit E is a statement prepared on behalf of the Markel family by their attorneys in conjunction with them. And it reads, Dear Judge Wheeler, we represent the family of Dan Markel, his mother Ruth, his father Phil, and his sister Shelley. On behalf of the Markel family and pursuant to their legal rights as crime victims under Florida law, we respectfully submit this letter to oppose defendant Charles Adelson's motion for pretrial release. And there's some law cited there. More than 8 years since Dan Markel was brutally murdered outside his home, justice has only been partially served. His boys are growing up without their father, and his parents are spending their elder years in searing pain, mourning the death of their son and the loss of their beloved grandchildren. The upcoming trial of Charlie Adelson is an important step on the path to justice for Dan, his family, and the countless friends, colleagues, and loved ones who continue to mourn him around the world. And there is still far more work to be done to ensure that every person responsible for Dan's brutal murder is held accountable. In our view, if Mr. Adelson is released pending trial, there is significant risk that he would flee, attempt to corruptly influence witness testimony, otherwise tamper with trial evidence, and or conspire with or be influenced by other co-conspirators. For all these reasons, his motion for pretrial release should be denied. And there's some law stated there as well. Tellingly, Judge Hankinson twice denied similar requests for pretrial release made by Catherine Magbanua, a convicted co-conspirator who faced the same charges for the same murder for hire, even without Mr. Adelson's substantial wealth and financial means to flee. Seriousness of the offense and weight of the evidence. On July 18, 2014, Dan Markel was shot twice in the head at point-blank range, just hours after dropping off his 2 young boys at daycare. This was not a crime of happenstance or wrong place, wrong time. It was a cold-blooded contract killing, premeditated, planned, and paid for by those who wanted Dan dead. No criminal offense could be more shocking or more serious. Dan did not die immediately. He suffered terribly in the hours after being shot, in what certainly were the most painful and terrifying final moments of life. In our opinion, the state has presented overwhelming evidence that Charlie Adelson, working with or on behalf of other members of the Adelson family, commissioned the contract killing of Dan Markel. Some of that evidence has already been presented to the jury in the trials of Sigfredo Garcia and Catherine Magbanoa, co-conspirators in Dan's murder who have been convicted of first-degree murder and conspiracy to commit murder. The conviction of Ms. Magbanoa, Charlie Adelson's former girlfriend, was based on evidence beyond a reasonable doubt that she was the critical connection between the trigger man who gunned down Dan in his own garage, Mr. Garcia and Luis Rivera, who pled guilty, and the members of the Adelson family, including Charlie Adelson, who allegedly commissioned Dan's murder. In our view, additional evidence to be presented at Mr. Adelson's trial, including the enhanced Dolce Vita audio recording, leaves no doubt that Charlie Adelson commissioned Dan Markel's murder. We are confident that a jury will agree and convict Mr. Adelson. The evidence putting Charlie Adelson at the center of Dan's murder is, in our opinion, devastating and inescapable. For starters, Ms. Magbanoa has already testified that she believes Charlie Adelson was involved in Dan's murder. Wendy Adelson, Charlie Adelson's sister and Dan's ex-wife, testified Charlie Adelson had explicitly talked about hiring a hitman to kill Dan, but bought her a new TV instead because it was cheaper than hiring a hitman. In the days and weeks before the murder and on the date of the murder, Ms. Magbanoa and Charlie Adelson were in frequent, regular contact with each other. Ms. Magbanoa often communicated with Mr. Garcia and Charlie Adelson with Donna Adelson in close proximity to those calls. During the 90 minutes immediately after Dan's murder, Ms. Magbanoa communicated with both Charlie Adelson and Mr. Garcia. Mr. Adelson and his mother, Donna Adelson, also spoke during that same time period. Then, in the weeks and months after Dan's murder, Ms. Magbanoa received thousands of dollars from the Adelsons, including paychecks for a no-show job at the Adelson Institute and a car. In April 2016, undercover law enforcement contacted Donna Adelson about Dan's murder, handing her a flyer about the murder with a request for $5,000 to help Mr. Rivera's family. Donna Adelson's first call after the undercover bump was to Charlie Adelson. She explained that a man had handed her some paperwork that involved probably both of us, probably the two of us. You probably have a general idea what I'm talking about. Charlie Adelson said, "What did they ask?" And Donna Adelson responded, "This TV was probably about 5, apparently using the code word TV to refer to Dan's murder." Donna Adelson told Charlie Adelson that the undercover agent had mentioned an ex-girlfriend, but did not name Ms. Magbanoa. Yet, after the call, the specific ex-girlfriend that Mr. Adelson called was Ms. Magbanoa, with whom he then met in person to strategize about how to respond to the undercover bump. Law enforcement recorded that meeting at the Dolce Vita restaurant. Among other incriminating statements, Mr. Adelson told Ms. Magbanoa that the individual who contacted his mother didn't mention his name, which led him to believe that these people only know part of the story. And of course, no plausible explanation has ever been offered as to why Mr. Garcia and Mr. Rivera, two gangsters from South Florida who had no connection to Dan Markel whatsoever, would have killed Dan, other than the obvious one. They were hired by members of the Adelson family through Ms. Magbanoa, the only known connection between each side of the murder-for-hire conspiracy. Flight risk. Charlie Adelson is a classic flight risk. He faces charges of first-degree murder, conspiracy to commit murder, and solicitation to murder, and the very real prospect of spending the rest of his life in prison. Mr. Adelson and his family have substantial wealth and the financial means to flee. Recorded telephone calls capture Charlie Adelson boasting about his expensive luxury cars, boat, and international travel. Mr. Adelson even discussed with Ms. Magbanoa his intention to flee in the event he was prosecuted. Evidence of both consciousness of guilt and of flight risk. On the enhanced Dolce Vita recording, Mr. Adelson told Ms. Magbanoa, quote, "If they had any evidence, they would have already gone to the airport." Sorry, we would have already gone to the airport. This court should not give him an opportunity to make good on that actionable threat. Witness and evidence tampering. There is a substantial risk that Charlie Adelson would attempt to corruptly influence trial testimony or otherwise tamper with trial evidence. Facing the prospect of an effective life sentence and a near certain conviction, Mr. Adelson has every incentive to influence witnesses who may testify at his trial. Some of those potential witnesses, such as his mother, Donna Adelson, and his sister, Wendy Adelson, are close family members who may also be implicated in Dan Markel's murder and may themselves be subject to future prosecution. There is a substantial risk that Mr. Adelson and his family members could strategize, coordinate defenses, script testimony, or work together to influence other witnesses. Any of these scenarios would threaten the integrity of Mr. Adelson's trial, as well as the ongoing criminal investigations of members of Adelson family members and other potential unindicted co-conspirators. Recorded telephone calls capture Mr. Adelson apparently discussing other serious criminal conduct as well, including trafficking in controlled substances, and demonstrate that he is capable of heinous violence toward others. For example, in the Dolce Vita meeting, Mr. Adelson tells Ms. Banois when the expletive police show up, and there's an oral surgeon standing there with a dead gang member in his expletive driveway, they're not going to come down too hard on me. And in a May 2016 call, Mr. Adelson discusses his willingness to alter patient records and to lie to his dental patients. After all of these factors, the serious murder and other felony offenses with which Mr. Adelson is charged, the overwhelming weight of the evidence against him, the lengthy prison sentence he faces, and the very real risk that he would flee, the risk that he would corruptly influence trial testimony, and the risk that he would conspire with or be influenced by members of his family, strongly support the denial of Mr. Adelson's motion for pretrial release. In the more than 8 years since Dan was brutally murdered, the Markel family has endured unfathomable grief and loss. Their only son was stolen from them, and members of the Adelson family have not allowed them to have a continuous and loving relationship with their grandchildren, Dan's 2 young boys. Throughout this horror, the Markels continue to fight for complete justice for their son and to be reunited with their grandsons. The interests of the public and of the Markel family as victims of this heinous crime support the denial of Mr. Adelson's motion. We thank the court for its kind consideration. Respectfully submitted, Orange Schneider, on behalf of the Markel family. All right, Judge. Exit. That's the conclusion of the evidence, Judge, for your consideration of the Arthur issue. I do have a couple additional exhibits I'd like to go ahead and proffer for your consideration if you find that the burden was not met or you choose to exercise your discretion and consider bond for the defendant.
All right.
I have State's Exhibit F, which are some iCloud text messages from Charlie Adelson's iCloud from both 2012 and 2013. These are just messages between the defendant and his father, unrelated to the case, indicating that they have access to a large amount of cash. So the first one indicates, Charlie, I spoke to Mom, and we will take the $26,000 in cash. The second one says, 27043 business and 3292 in personal, deposited over $25,000 cash for you in safe. Love, Dad. And the third one reads, I know that, I just need to discuss the accounts. The 2 accounts that I hold have $346,000 in cash and require more time to send for a reason that I can explain if necessary. Love, Dad. And that's marked as State's Exhibit F, Judge.
All right, let's just be clear for the record. Any objection?
No, Your Honor, as long as we can get a copy of whatever she's admitting.
All right, you have a copy for defense?
It doesn't need to be right now if she doesn't have it, just after the hearing.
All right.
The messages have been provided, but in a big iCloud, so I can provide those 3 sheets.
All right, they'll be admitted as Exhibit F.
All right, and then State's Exhibit G. This is a portion of a transcript from a videotape deposition of the defendant in reference to a unrelated civil case that was conducted on December 14th, 2021. And I've included page 1 and 2 of the deposition, 1, 2, and 3 that tell you what it is, where it was conducted, who's doing the speaking, and the table of contents. And then I've included pages 23 through 28 of the deposition, which is relevant to show Your Honor what a more current picture of their financial abilities is at this time. It indicates that Mr. Adelson, the defendant, has sold several businesses to his father recently, and also sort of gives you the status of some of the properties and businesses that he owns. And then I also included page 389 on the back, which is just the certification from the court reporter authenticating this document.
All right, Exhibit G has been offered. Any objection?
No, Your Honor.
Be admitted as Exhibit G.
All right, and lastly, Judge, I just have the PowerPoint that was presented today, which I would offer as just a demonstrative exhibit for the record.
All right, it'll be admitted as a demonstrative exhibit.
And just a couple other points on the financial abilities, Judge. I know there were several calls on State's Exhibit 99, which was introduced today as State's B, which discussed the financial abilities of Mr. Adelson and the significant financial resources of his family, but also witness Mary Hull, our financial analyst, testified that between 2013 and 2016, when our crime occurred, Adelson Institute was earning about $1.5 million a year. Charlie Adelson himself was earning approximately $3 million a year. That the family in total had approximately 18 investment accounts, including multiple properties. And then I would also just point out the evidence that was elicited regarding Charlie Adelson doing favors for Catherine Magbanowa, in addition to the car and the breast augmentation, but also vacations, and of course the payroll, putting her on the payroll. May I have one moment to confer, Your Honor?
You may.
In closing, Judge, the state has met its burden of proof evident or presumption great by the great weight of evidence in this case. There is a lot of circumstantial evidence, and the devil really is in the details here, but the statements made by the defendant on those wire calls and in that Dolce Vita recording are very, very compelling, and we would ask Your Honor to hold this defendant without bond, to protect the community, to preclude the potential for a flight risk, and to make sure that justice is served in this case. We do intend to try the case relatively soon. The defense and I have discussed a February or March trial date for this case.
All right, are you making the argument that any of these statements in the Dolce Vita video are direct evidence as opposed to circumstantial?
I do think all the statements of a defendant are direct evidence in addition to all the circumstantial evidence.
All right, thank you. All right, Mr. Rashbaum, will you be calling any witnesses?
No, Your Honor.
Just presenting argument today?
Yes, Your Honor.
All right. You
May I
may
approach, Your
proceed.
Honor?
Yes.
Judge, good morning.
Morning.
Nothing has changed since September of 2016, when the state allowed a draft probable cause affidavit for the arrest of Mr. Adelson to be released to the media. We've just heard 45 minutes of testimony, and if you look at that draft affidavit, it's virtually identical. Nothing has changed. Sure, there's been convictions. There's been convictions of Mr. Rivera, Mr. Garcia, Ms. Magbanowa, but none have offered direct evidence against Mr. Adelson. Ms. Magbanowa was offered immunity, a get-out-of-jail-free card, for approximately 7 years. She was offered it several times. All she had to do was give direct evidence against my client. She never did so because there was none. The evidence is the same today as it was back in September 2016, when the then prior state attorney, Mr. Meggs, said this evidence is, quote, mere speculation lacking probable cause for an arrest. Nothing has changed. And this is a different case than Ms. Magbanua's case. In Ms. Magbanua's case, when Judge Hankerson heard this bond hearing, there was direct evidence. There was direct testimony. The testimony of Luis Rivera. No such evidence exists as of date in this case. There was no arrest in 2016, 2017, 2018, 2019, 2020, 2021, not till days before Ms. Magbanua's retrial in 2022 was Mr. Adelson arrested. For all those years with the same evidence, the state felt that Mr. Adelson was not a flight risk. The state felt that Mr. Adelson was not a danger to the community. Nothing has changed. Now, what does the state say has changed? This supposed enhanced recording, the Dolce Vitae recording. Well, I have all the recordings, Your Honor, and it's the same evidence as in 2016. In 2016, if you look at the draft affidavit, they're relying on the Dolce Vitae recording. Ms. Kappelman herself, just last month, went on a podcast where she admitted that, quote, she always heard what was on the recording, that you could make it out from the beginning if you labored through it. Nothing has changed. In other words, the facts didn't change. And by the way, when the recording is examined closely, as we will do at trial, when it's picked apart, you'll see, without cherry picking, that it exonerates Mr. Adelson. That's what you'll see from the recording. And we're going to talk about the airport comment in just a few minutes. But repeatedly in this recording, Mr. Adelson says that he hopes that the confrontation is the police. That's what he says. If they are the cops, I'm happy because I have nothing to hide. Talk about an alternate explanation, an alternate hypothesis on their best piece of evidence. Repeatedly, he says in their best piece of evidence that he had nothing to do with the murder. He has nothing to hide. He says that at least 5 times in the recording. And I believe he says that a couple more times in the unintelligible parts of the recording, which we're working on making intelligible. The government simply cannot meet its high burden of keeping Mr. Adelson detained. In this case, the evidence is clearly circumstantial evidence, no direct evidence. So the government has the burden under state law of excluding every other hypothesis except that of guilt, which it cannot do. The Dolce Vitae recording itself shows other hypothesis of innocence. Not one single witness establishes Mr. Adelson's involvement, and Dolce Vitae itself shows his innocence. The wires itself shows the innocence. Now let's use the airport line as an example. So the government comes up here and they read the first line that they have in their intelligible recording. Remember, there's about 30 minutes of the recording before the statement, including a large section which the government says is unintelligible. And the line that they read is, if they had any evidence, we would have already gone to the airport. Judge, you have to take it in context. You have to take it into context of what's said before, and you have to take it into context of what's said after. And when you do that, when you dissect the recording, as we will do at trial, you will see that what Mr. Adelson is saying is, they don't have any evidence because I had nothing to do with this. That's what he's saying. But Judge, you don't have to take my word for it. And you don't have to take the government's word for it. Because here's what we know definitively, not without guessing of what's said on a recording or guessing what's meant by wires. We know what actually happened. So the Dolce Vitae recording happens in April 20th of 2016. That's when this airport comment is made. The arrest of Sigfredo Garcia happened shortly after. Mr. Adelson, he doesn't flee. He stays put. Okay? September 2016, the government releases an affidavit to the press that lays out exactly their theories of the case. Exactly what they just spent 45 minutes telling you today. That release is put all over the press. 2020, Dateline, Tallahassee News, USA Today, New York Times, the BBC. Does Mr. Adelson flee? Nope. Doesn't go to the airport. Well, actually, he does go to the airport. He goes to places that he could never be extradited from in a capital offense, and he comes back. Okay. October 2016, Miss Magbanua is arrested. Sounds like pretty strong evidence. Does Mr. Adelson flee? No, he stays here. December 2016, there's a bond hearing in this courtroom, I believe. During the bond hearing, the government again lays out the theory of the case with Mr. Adelson as its centerpiece. Does he flee? Nope. Reports of immunity come out in the press. They're offering Miss Magbanua, she can get out of jail. All she has to do is turn on Charlie Adelson. You heard that testimony. Does he flee? No. Conviction happens of Mr. Garcia, hung jury of Miss Magbanua. Does he flee? No, he never flees. That should tell you, when you look at the context of this comment, it's taken out of context by the state. And what you're going to see in the trial is many of the supposed evidence that they have, the circumstantial evidence in the wires, on the Dolce Vita video, taken out of context. You don't have to guess what Mr. Adelson meant when he said, if they have evidence, we would have already gone to the airport. They've had all the evidence for 7 years, nearly. He never fled. Now, Judge, even if you somehow find that the state is able to establish its incredibly high burden here, you still have discretion to grant bail and should do so. May I have a moment, Your Honor?
You may.
First of all, Mr. Adelson has no criminal history. There is no doubt about that. I understand the letter from Gibson Dunn, and I understand that they're doing their job. But they can't point to any criminal history. They point to a line in the Dolce Vita recording where Mr. Adelson is talking about how he will defend himself. That is not anything about criminal history, a bad criminal history. There is no dispute in this case that Mr. Adelson, a man of 46 years of age, has no criminal history before this case. During his arrest, he was fully cooperative. As I've just stated, he has never fled since 2016. The state has obviously never considered him for the past 6+ years to be that great of a danger or a flight risk that they needed to arrest him in the last 6 years. Now, this letter also talks about tampering of witnesses. Well, again, the state clearly wasn't worried about that from 2016 to 2022. And I'm not sure what witnesses Mr. Adelson would tamper with. There's been 2 trials. There are trial records of the witnesses who have taken positions. I'm not sure what witnesses they're referring to. Judge, when looking at taking discretion, you should do a balancing act. I think that's what the courts say. And what I want to bring to the court's attention are the major challenges that we have in preparing a defense and for Mr. Adelson to participate effectively in that preparation of his defense while in jail. And some of this has come to light since our last hearing, and frankly, may delay the trial, as you're about to hear. So, what I don't know that Your Honor is aware of is, since being arrested, Mr. Adelson has been in protective custody. What that means is that he is in solitary confinement. And he's in solitary confinement because of the publicity of the case. The prison thinks that's the only way to protect him because of the publicity of the case. As a result of that, he is allowed 30 minutes a day outside of his cell. On weekends, he sometimes doesn't get out at all. He has phone call capability, but those phone calls are during specific times in the day. And the phone calls get cut off after 30 minutes. He has to recall. There's also a high cost to those calls, but that's not an issue here. We filed a motion with the court to allow him to listen to some wires. I'll tell you what we've been doing, Judge, is we spend as much time as we can going through wires with Mr. Adelson on our phone call, where we literally are sticking a computer near the phone and then trying to go through it. As you can see, it's not ideal, but we're doing the best we can. Your order said to the prison that they should use reasonable efforts to allow Mr. Adelson to listen to these wires. So we provided the prison, and they received it on, I believe, August 23rd or 24th, an MP3 player with these wires. Now, these wires are around, give or take, 600 hours of wires. Those don't include the wires related to Luis Rivera in his separate case, but related to this case, they're around approximately 600 hours. Since August 24th, Mr. Adelson has not been allowed 1 minute to listen to those wires. And when I spoke with the jail yesterday, they informed me that he would be allowed soon to start, but that because of a shortage in staff in the prison, he would be allowed 3 hours a week to listen to those wires. Now, I'm not great at math, but we can do the math. 600 hours, if he gets 3 hours a week to listen to wires, it's going to be pretty hard for him to hear all the supposed evidence that's against him. We've also been told that we have to go through special channels and speak to the chief of the jail to get a computer in the prison for us to use with Mr. Adelson. So, for instance, the videos today, Mr. Adelson has never seen. We have. The government has been terrific with discovery. We have no arguments with the government. They've been terrific getting us discovery. Sure, there's bumps in the road. They've helped us through it. So we have no arguments with the state. Mr. Adelson, we can't get a computer in to show him videos. He obviously can't get a computer in. We've been told we have to call the chief of the jail. I've called him now 36 times. I've gotten one call back where he said he would get back to me. We'll keep trying. There's a 2-hour limit on attorney visits with Mr. Adelson without special permission. And I've been told that the special permission is hard to get, again, because of the shortage in staff. There are, by my estimation, 57,542 documents that have been turned over to us in discovery. Not pages, documents. It took the jail 1.5 months for us to get Mr. Adelson the 3,500 pages of trial transcript from the first trial. And the reason being is we can't just FedEx the trial transcript that's given to them. We need to FedEx it to them, and then they need to make photocopies of it. So imagine all the other 57,000 and change that we haven't been able to get him yet. The jail just doesn't have the capacity to make photocopies of such items. And we have no other way to go through such items with Mr. Adelson. Judge, we are working hard. We are doing everything we can. We're having, as has been reported on the media, hours and hours and hours of phone calls with him every day. But there's only so much we can do under these circumstances to effectively prepare our client for trial. And there are appropriate conditions to his release. Home confinement, monitoring. We'll pay for 24-hour police security to watch him at the house. We'll tie up any assets that you think need to be tied up. He's been free and has not fled, has not committed a crime in 2016 and onward. There's no reason to believe he will do so now. That's why we're asking for a bond, Your Honor.
All right, thank you, Mr. Rashbaum. All right. The court is in a unique position here because I sat through the other trial, which is what has been offered into evidence by the state, the entire trial and evidence from that trial, the wire calls, the recording from the Dolce Vita meeting, the recording from the Matsuri meeting is additional evidence that has been reviewed and by the court today. Also, there's some iCloud texts and depositions that has been presented to the court today. So I have reviewed all the evidence, so I am in a position to make a ruling. The court finds that based on the evidence provided by the state, that the state does meet the standard of proof evident or presumption great that the defendant has committed the 3 charged crimes. Not only is there direct evidence the court finds from the Dolce Vita video and statements made therein, but there's also a wealth of circumstantial evidence against the defendant. Even if a court subsequently finds that there was only circumstantial evidence, I find that the evidence presented by the state certainly rebuts every reasonable hypothesis of innocence. So I find that the first part of the test is met and proof evident or presumption great standard is met by the state. Secondly, the court will not exercise its discretion to release the defendant due to the nature of the crimes. I find that he is a danger to the community. I additionally find that he is a substantial flight risk based on the evidence that's been presented. Particularly concerning is his statement in the Dolce Vita video about getting to the airport, if there was any evidence, but there is also other evidence that he is a substantial flight risk, and so therefore the court will continue to hold him no bond at this point. Mr. Rashbaum, I acknowledge the difficulties that you have in preparing for trial, and I'm going to assist you in any manner that I can within the confines of what's required at the jail. What I propose is that with what you have detailed to me in your argument today in regards to your client not being able to listen to the wire calls through the MP3, which I had ordered before specifically, the use of the computer in the jail, your limit on attorney's visits and the time that's required for that, and your need to get documentation to the defendant. I think I've identified those particular 4 things. If you could put that in a motion and offer in that motion what you think is a reasonable or what you're requesting so that you can have preparation time with your client and review it with the state. I don't think the state's going to have any issues with most of the things that you propose because I think that they want to move this forward also. I will assist you in any manner whatsoever with contacting who I can within their limited resources at this time, but I think we do need to move it forward, and sometimes it might take an order from the court in order to do that. So put it in a paper motion with the proposed order. Make sure that in that motion whether or not there's any objection to the state, but I've identified those 4 things. If there's any additional ones that you need for your preparation that are reasonable, I think these are reasonable, then also put those in your motion. We'll consider it. I don't think we will need a hearing on this. If we do, then I'll hold that hearing by Zoom so that we can get it done quickly and efficiently.
Thank you, Your Honor.
Okay. Ms. Kappelman, so that we're clear for the record, if you could please prepare a short order that says, for the reasons stated on the record, that the motion for pretrial release is denied, and then that way we have it clear in the record for any further review that's necessary. All right, so the next thing that we have on the docket moving forward is we have a case management in December. If we get this motion and some action from the jail, then I think at that time we'll have a better indication as to whether or not we'll be ready for trial come February or March. I've been looking at dates for that. The one consideration in March, and I don't think it's for the convenience, it's not for the convenience of the court or really for anybody sitting here, but spring break is in March, and so we have to think about that in terms of getting jurors and whether or not it's going to interfere with those plans. So I think that's later in March, so I was looking at dates possibly end of February, beginning of March. But let's have a better idea. If we don't do it then we're probably looking at April or May, because we can't do it in late March. We're just not going to have the jurors. It's just going to be too much of an inconvenience for them. We're already dealing with enough issues in regards to getting jurors. So let's keep that in mind. And I think we'll have a better idea of where we're headed at that case management so that we can definitely blank out some dates then, either end of February, beginning of March, or if we're heading into April or May. Okay, any discussion in regards to that? Ms. Kappelman?
No, Your Honor.
Anything from the defense, Mr. Rashbaum?
No, Your Honor. I think we'll have a good idea in December.
All right, great. If you can get that motion to me as quickly as possible so we can get moving on these for you, and then we'll be in a position to know come December. All right, Ms. Kappelman, anything else for the court?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, thank you both. We'll be in recess. Thank you, Madam Clerk. How are you doing?
It is not true, but it's okay because he's not safe in general law. But I think they're making the right call. But thank you. Yeah, I'll keep driving. Keep you company. I will. All right, you can help us find stuff. Good luck. Thank you, doctor.
I'll tell you what it says. It's got captions on it, so if you want to get a copy, you can get the copy with the captions.
Okay.
But yeah,
What,
basically.
what made you think this was an appropriate time to reveal that piece of evidence?
So it's a conversation between Harvey Adelson and Charlie Adelson, so it would only be relevant again. Anybody else?
Then I guess we glad with the judge's ruling. Jail, yeah.
Yes,
Okay.
we're happy with the judge's ruling.
All right.
And what's next?
Case managements and hopefully a trial in the new year.
Georgia, are you confident that Charlie will have enough time with the MP3 player to review?
Yes, I'm told that as of yesterday, the jail was working on trying to amend that, and I'm sure with the judge's comments today and his offer to issue an order to that effect, we can accommodate his need to look at as much as he wants before trial.
Thank you, George.
Thank you, Georgia.
Thank you.